The lovely and talented David Kopel is not just a star of stage and screen here and at the Independence Institute. He's internationally renowned and freshly back from a senatorial testimony at the United States Senate. I don't know if I should be impressed or just a little sorry for you.
Oh, it went well enough, so you don't have to feel sorry.
Oh, trust me, I feel sorry for you. All right, I want to talk about red flag bills or extreme risk protection orders, or what we have here in Colorado now, which will be a gun confiscation bill. But this is something that's going on from state to state, and you were asked to come to the Senate Judiciary Committee to talk to them about it.
Yes.
I saw your testimony. I even read part of your 30 pages almost of testimony. I was amazed to find out how accordion this term is, red flag laws. Give me a definition. A red flag law is what?
Oh, it's the marketing term invented by the gun confiscation lobby. The law term has changed over the years. They used to call them gun violence restraining orders. Then they invented this term, which is now in Colorado law, extreme risk protection orders.
Extreme risk.
Well, and I'm in favor of extreme risk protection orders, but there's deceit in that name because they're not about extreme risks. They're about much lower risks. Vermont has a good law that's about extreme risks, and that's the kind of thing I told the Senate Judiciary Committee, which is considering federal funding to incentivize states to adopt laws like this, is they should be accurately labeled. And if you call a bill extreme risk, then it should be about extreme risk.
Let's go from the general and then we'll go to the specific. It seems to me that if somebody is of a danger, a family member or the police go, this guy is a danger to himself or others, shouldn't we take him out of society until we find out instead of taking his guns? Because he can still use baseball bats and knives and cars and other guns, which are not difficult to find. So isn't this a bait and switch, that this is a mental health issue, but really we're going to disguise it as a way to take guns?
Certainly people argue that. I would say the counter argument is that not everybody who's the subject of this is necessarily somebody, if you put them in an involuntarily 72-hour mental health hold, that they would end up being detained longer. Not everybody who's an extreme risk is mentally ill. I mean, look at just for example the perpetrators of the San Bernardino crime. That guy and his lovely Pakistani wife, they were not mentally ill. They were quite evil. But if you'd put them in a mental institution for evaluation, they would have walked out fine.
One of the things you mentioned in your testimony was how many innocent people have their guns removed from them. I found that shocking. I mean, I knew it could happen. I didn't know it happened as much as you reported.
It happens about a third of the time, and that's even in states which have stronger protections against it than the new Colorado law does.
Stop. A third of the time you are disarming somebody who should not have his Second Amendment rights taken away from him.
That's correct.
That seems like a huge amount of either abuse or overreach, or the system just not working.
Well, it's a system that's designed to fail in some ways. When you say you can have the initial confiscation order all the time, normally, just by one side going into court, and then
that's called ex parte.
Ex parte, exactly. And then you have a very low standard of evidence for that first ex parte hearing. Then you get a lot of confiscation orders issued that turn out to be wrong. So in Connecticut and Indiana, where then a few weeks later, the individual had his guns taken, gets a chance to tell his side of the story in court. Courts overturn the confiscation orders 32% of the time in Connecticut, 29% in Indiana.
But this is a constitutional right. There's First Amendment. You have a right to free speech. You have a right to religion. You have a right to press. You have a right to this. You also have a right to personal ownership of firearms. The Supreme Court made that clear with the Heller decision. How is it that you could just take away somebody's constitutional right and then go, oh, hey, we were wrong? Isn't that a pretty severe thing? Wasn't there a time where liberals would scream bloody murder about that as a violation of due process in the Fourth Amendment and the Fifth Amendment? Forget the Second.
Well, yes, and good liberals would still say the same kind of thing. For example, that's why the American Civil Liberties Union of Rhode Island opposed a similar law in that state. But part of the problem is there's not that many liberals like my dad or Walter Mondale or John F. Kennedy and those kind of folks
What was the
around
ACLU
anymore.
in Colorado on this terrible law?
Sadly, I think they didn't get involved in it.
Wow. So help me with this again, that you have a lower standard to take somebody's guns, and then they have to prove their innocence to get their guns back?
No, usually it's at the stage 2 where the way the Colorado law and some other states are set up is you have the accuser come into court. You only hear the accuser's side of the story. In fact, the accuser may not even come in court. The accuser might just testify by telephone. So you have the judge hears only one side, and it's a low standard of proof. Then the judge issues a confiscation order. The first that the gun owner knows is when the police show up at his or her home at 5 o'clock in the morning and say, "We're from the government and we're here to confiscate your guns." Then a couple weeks later, then the gun owner, or former gun owner, gets a chance to tell his or her side of the story in court. And then at that point, the burden of proof is still on the government, or the petitioner, the confiscator, at that point.
Is that the right way to do it? I mean, are you advocating that's the way it should happen?
No, I think that that should happen in cases of necessity. So, for example, in Vermont, they say you can't do this. You can only do this thing ex parte when you don't hear from the guy who's going to be the subject of this order. You can only do ex parte when there's proof of an extreme and imminent danger. And I think in that situation, it is okay to be ex parte.
All right, and I'm not the lawyer, you are. These words have different meanings. So say it again.
Extreme and imminent danger is the standard in Vermont for ex parte. And I agree with that, and I think that should be a national model.
By contrast, what is the standard here in Colorado should this bill become law?
Oh, it's going to be a significant danger, which is significant, but significance less than extreme.
That is the term of art, significant
Yeah,
danger.
yeah.
So it's not extreme danger or imminent danger, it's
No,
significant.
that's why the bill violates the Colorado Constitution, among other things, because our Constitution says that every bill shall have a title which clearly expresses what it's about. And when the title of this bill is Extreme Risk Protection Orders, and you won't find the word extreme anywhere in the bill other than they say extreme means significant, which is, fat means 3 pounds, obese means 5 pounds overweight. You can make up the words, I suppose, but it's not. It's deceptive to the public.
All right. Put Colorado's confiscation bill aside for a second. If you're talking to the Senate committee, you told them that these are certain things a good red flag bill would have.
Yes.
What are those things? Give me the top few.
Strict limits on ex parte orders.
In other words, overwhelmingly, the guy you're taking the guns from needs to have a say in this, unless, of course, there is some massive extreme risk.
Unless you show some good reason why you shouldn't. Just like in ordinary cases for temporary restraining orders, you better come into court, the Colorado and Federal Rules of Civil Procedure 65, have some explanation of why you want this court to issue an order against a guy who you didn't even tell there was going to be a hearing.
Next thing that one of these should have, if it's going to pass the Coble test.
The Vermont model, which is some states, including Colorado, have a situation where a ex-girlfriend, ex-boyfriend, some kind of distant relative with a grudge, whatever, can put law enforcement on autopilot and force them to show up at somebody's home to confiscate their guns immediately. Vermont makes it a less confrontational situation where it says the person who's the subject of the order, instead of having law enforcement haul the guns out of the house, they can instead take the guns to a licensed firearms dealer or to some other responsible third person. Now that has to be done quite promptly, but there's still that's an alternative to putting the burden on law enforcement to arouse all the animus that comes from confiscating an innocent person's guns, and we know they're going to be innocent at least a third of the time.
To put it in my terms, hey, listen, Dave, you need to give your guns either to the police or give them to the gun dealer or your cousin Bob. Here's a court order, you need to do that. Versus, or no-knock raid, middle of the night, give us your guns.
Well, and that's another thing is states have different controls on no-knock raids. Colorado, you need to get, a district attorney needs to get a warrant from the court specifically for a no-knock raid. normally, but this bill wipes that out. All the normal protections that people have against no-knock raids in Colorado disappear when it's a gun confiscation raid based on this low standard of evidence. Again, somebody who may have just called the court, not even showed up in court where the judge could examine the accuser's credibility and demeanor.
What about people who can't afford a lawyer, don't understand this? When the government comes and takes your property, I thought we had due process laws, but apparently we don't. That you also should be compensated for this, or there should be a way to get your guns back. You're worried that might not happen.
Well, the Colorado new law does have a good feature, which I suggested if we're going to have federal funding for state laws, this is a good thing to fund. Colorado is going to provide appointed counsel for all the respondents to these orders, and that's a very good and positive step. And the sponsor, Representative Garnett, deserves a lot of credit for putting that in there, because in lots of other cases, like we know from Connecticut, the state's attorneys actually brag about their techniques where they talk people out of even paying for their own lawyers. Incredible.
All right, what happens if a woman has her gun taken and something happens to her because she can't protect herself? It's something that guys don't think about as much, but women think about a lot. That for those weeks where she's falsely accused and has to get her gun back, what happens if something happens to her?
Well, and that's exactly what the kind of tactic the stalker or the angry divorcing husband can use. And this was a subject of a huge amount of testimony in both houses of the legislature, as lots of women who had been through rough divorces saying, man, if this bill had been law back then, my husband definitely would have used it against me.
I guess what I'm asking, we've only got 30 seconds. If something happens and a crime is committed against somebody who otherwise would have been able to defend themselves, is there any recourse for that person to sue the government over it because they're the ones who made this happen?
You would think there should be, but there isn't. So the government won't even help pay for the funeral.
Again, I keep asking myself, what happened to good liberals? Whatever happened to due process liberals, the ones who said the ends don't justify the means? People want to see this testimony. Where do they go? Because it is an important read.
To my website, davekopel.org, and it's right up there at the top of the page.
davekopel.org. davekopel.org. Thank you. Listen for me on KHOW Radio. Read me in the Denver Post. Check out the Independence Institute at thinkfreedom.org. And we'll see you next week.